Hello, students. So what we're going to talk about today deals with civil liabilities. And we've been talking about criminal issues. And so now we're going to move towards civil issues. And so what are we talking about when we mean or when we say civil liabilities? So the first thing I want to do is give you an outline of what the text says. I think this will be a good thing for you as you're working through your projects later in the semester. So what we're going to talk about here is we'll start off with discussing torts. A tort, it all comes down to a tort, and that is going to be what we determine to be a civil liability. And in the tort, we're going to see that there are two things: assault and battery, false imprisonment. We're going to talk about strict liability. And the third area is negligence. And under negligence, we'll talk about standard of conduct, a reasonable person, a reasonable and prudent teacher, and elements of negligence. In other words, how do we define negligence in duty, standard of care, proximate or legal cause, injury, or actual loss? And then if we're accused of negligence or if we're accused of a tort, what are the defenses for negligence? And the defenses that we have are contributory negligence. As we'll see, is not used very much. Comparative negligence is becoming more popular. Assumption of risk, exculpatory notes, we all use them. Act of God, immunity, safe harmless laws, bullying, and statutory teacher protection. And finally, we'll look at educational malpractice and constitutional torts. So it won't take too terribly long, but all this involves torts. So then the question becomes, what is a tort? And a tort is a civil wrong against a person. So it's easy to define. If it's a criminal wrong, in other words, you have broken a law, you have committed a wrong against the government of the state or of the county of your city or of the federal government, the United States, the country. If you commit a wrong against a person, it may not necessarily be breaking a law, but it's a wrong against a person, then you have violated a tort. Okay, and so that is where the definition comes from. That's where we understand the difference. So a tort is something that you're going to do that you can't necessarily go to jail for, but as we'll see, you can have penalties for it. It's created by common law and not by conditions of a contract. A contract would be a legal obligation. There are two types of torts: a commission of a tort or an omission of a tort. Failure to act accordingly may result in a tort. And as we'll see, as far as teachers go, this means that if it can be expected that you should be protecting children, and one of the areas used a lot in the text is dealing with science. So if you're a science teacher, it is understood that you're going to teach your students about working in a lab and so forth, so that when they go into a lab, they can conduct their experiments in a safe manner and environment. Failure to teach this would or could result in a tort. Okay, so that's where we're going with this. Intentional interference. Intentional interference here involves assault and battery. And straightforward, assault is being placed in fear and apprehension of immediate physical contact. This would be obviously a teacher waving their hand in front of a student, threatening to hit the student. That would be assault. Notice it is being placed in fear and apprehension of immediate physical contact. It is not actual contact. That comes in when we deal with battery. Okay, so know the difference between those two. Assault is a student having the fear of being battery, and battery is the actual laying hands on the student. And the courts have interpreted this in an interesting way. For example, a guy, I think it was in this area where a gentleman sued for assault because somebody said if you were younger, basically if you were younger, I'd lay you out. And so the guy sued him for assault, and the judge said you were not in fear of physical contact because the actual content of the conversation was if you were younger, I would lay you out. And so therefore, that negated the fact that he was going to hit you. So that's assault and battery. Now, where does corporal punishment come into this? We talked about corporal punishment a little bit earlier. Corporal punishment is not assault if it is reasonable and not excessive. Keep in mind, corporal punishment is legal in Oklahoma. And this comes through the Baker-Owens case back in 1975. The Supreme Court affirmed the decision without comment, meaning that they affirmed the decision that corporal punishment was legal. It was not excessive or cruel and unusual punishment against a child. It goes back to the idea of in loco parentis, where the district or the school and the teacher specifically are acting as the parents, in place of the parents during the school day. And as we'll see, this holds teachers to a higher standard on many things. But because of that, corporal punishment is allowed in schools. Corporal punishment did not constitute cruel and unusual punishment, as I just said, and parent consent not required before using the technique. Now, I would have to check Oklahoma statutes on this, but I think that the Oklahoma statute says that it is. I would advise you never, if you use corporal punishment, never to use corporal punishment without notifying the parent. We always call the parent beforehand. The parent signed permission slips at the beginning of the year, and we would call the parents beforehand, unless we got to a point where they said, just don't call me anymore. And we had a few that got to that point. But anyway, technically the Supreme Court said in 1975 that parental consent was not required. And of course, the main thing here goes back to probably, I'm sure they referenced Tinker in all of this, because Tinker, because Tinker said that schools have a right to maintain an educational environment, and that's what Tinker said. And because of that logic, schools have a right to punish a student they feel is in need of punishment. Ingram versus Wright, 1977, was another case dealing with corporal punishment. Again, it allowed corporal punishment, restated that it is not cruel or unusual, and said that teachers and school officials can use corporal punishment. Corporal punishment is an infringement on the constitutionality protected interest. And here we're talking about bodily restraint, unjustified intrusion on personal security. I think that's it. Yeah. Well, however, no prior notice of hearing is needed, and denial of school attendance is worse because it deprives students of a property right. So in other words, this is justifying the use of corporal punishment, saying that corporal punishment in lieu of suspension is acceptable because suspension deprives the student of a property right, which is guaranteed to the student, a free and public education, as we will see later. So the bottom line on corporal punishment is, as we said earlier, it is legal. It does not constitute battery unless it becomes excessive. Now, interestingly enough, the book Alexander and Alexander, the authors of our text, stated that the courts have even said that I forgot how it was phrased in the book, but it's not uncommon for a child to have slight bruising as a result of corporal punishment. Uh, on a side note, in talking to my school lawyers, when I was principal, the school lawyers said that if the school were sued, they would not represent the school. And therefore, once they said that, we stopped administering corporal punishment in the middle of the year as soon as they said that. About 20 years ago, a friend of mine had been accused of battery as a result of corporal punishment and was arrested on campus during the school day, taken out to the car in handcuffs, and later exonerated of the charges. But that still didn't change the fact that he had been arrested. And so we just stopped corporal punishment altogether about 2 years ago, 2.5 years ago, right before I stopped being principal at the school. Another form of tort here is false imprisonment. And this comes in when we're talking about the unlawful restraint of one's physical liberty by another. School officials have legal status as in loco parentis. And basically, false imprisonment doesn't mean that you can't hold a student in your office for the day, tell the student they have to stay in your office for the day. It goes beyond that, okay? It's mentioned in the textbook, but to be honest with you, I've never heard of a case that I've dealt with principals where they were ever accused of false imprisonment. Here's the way to get around that. You call the parent and tell the parent what's going on, and that you're going to keep the child in your office, you're going to put the child in detention for the day, and if the parents don't want that, then tell them they have to come get them or send somebody to come get the child. That's how you get around those kinds of issues. In dealing with a child concerning false imprisonment, detention must be relatively short, made in good faith with no malice. In other words, it cannot really be arbitrary. The best interest of the student in the school, again, we go back to that idea of the best educational environment for the school. And so that deals with false imprisonment. Now, there was another kind of tort called strict liability, and this is nearly non-existent in schools. It requires a causal connection between the act and an injury. And the only thing I could think of here is I remember a case where a school district had built a fence around a soccer field, and the fence was about 5 foot high, and there was a young kid, and the young kid had climbed the fence, went out onto the soccer field, and was climbing on the goalpost. And one of the goalposts fell, and I believe that it landed on the kid's head and killed the kid. And the kid's parents sued the school under strict liability, and the courts ruled in favor of the parents in this instance and said that because the fence was not built high enough to keep the kids out, the school was liable for it. And so even though there was a fence there, the intention may have been there, but the school did not take enough precaution to protect the child. And so that was the causal connection between the act and the injury. They said the school did not do enough precautionary measures to take care of the child. But this is rarely used in schools, okay? And we'll deal a little bit more later. Usually what we see happening in schools is negligence. And this is the third and largest area dealing with tort claims against teachers. Negligence can be defined as conduct falling below a legally established standard which results in injury to another person, failure to exercise due care when subjecting another to a risk or danger which causes harm. And, this can obviously bring up a lot of different scenarios. I'm thinking here of a coach and athletics, and there were cases in the book about parents who sued because their children were hurt in athletics, and the courts came back and said that the school was not liable because of the fact that the coach had taken the precautionary measures, and therefore the risk was understood by the parents. Now, where this would come into play, as athletic director, every year one of our most single largest expenses in the athletic budget was repairing football equipment. And we would take and have helmets conditioned. Every year we had, I think, a third of the helmets conditioned every year. And that was very expensive, but that would be an issue where if we had not done that and a student had been injured and came back, then that would be an instance of negligence, and a parent could file a tort claim against the coach, the athletic director, the superintendent, principal probably, and it would be under failure to exercise due care when subjecting another to a risk or danger which causes harm. Standard of conduct under negligence. There are a list of things under negligence that a person can be negligent for. For standard of conduct, reason to exist, injury must have occurred from someone else after being exposed to an unreasonable risk. Your book goes into detail talking about a reasonable person. And basically, it says that, when we're talking about standard of conduct and saying that injury must have occurred from someone else after being exposed to an unreasonable risk, a reasonable person is not going to put somebody at a reasonable risk. And so this is one of the things the courts look at in determining whether somebody is guilty of negligence in the sense of standard of conduct. A reasonable person is a prudent person, a person of average prudence, a person of ordinary sense using ordinary care and skill, and a reasonably prudent person. I know we keep using the word prudent there, but that's the definition the book used. A reasonably prudent teacher is a little bit tougher, okay, and as that idea of in loco parentis comes in, if the teacher is acting in lieu of the parent, then it's expected the parent would take more caution with their own children. And so we see the same here when it deals with teachers acting in loco parentis. So a reasonably prudent teacher then is going to be held to a higher standard than a prudent person, since teachers say they possess superior skills and understanding of the educational processes. Again, we go back to in loco parentis. And I want to just hit on this just a second here, because it would be interesting, I think, to see about teachers who do a fast track for their teacher certification. Part of the teacher education program, as you all know, is taking those educational courses dealing with learning theories, learning development, child development, and so forth. And it's because of all that that teachers are held to a higher standard. That in the sense that they are working in lieu of parents when taking care of children. And so based on this, the courts have said that teachers should know better and are expected to know better. So my question then is, what about teachers who don't do the traditional teacher courses, such as the EDUC and so forth, and do a fast track? And I'm thinking of people like Teach for America teachers who go to summer boot camp for 3 or 4 weeks and get their certification to be teachers. So I think it's an interesting study there for someone to do when you move off onto graduate school and work on your next degree, your doctorate degree. So anyway, I just put a bug in your ear there for that. Negligence of duty. No duty with no reasonable foresight of danger or risk. In other words, if a teacher understands and estimates the potential for harm and takes the necessary precautions, then there's no negligence of duty involved. And this goes back to, again, that teacher who works in a chemistry lab and doesn't teach students about mixing chemicals. Okay, that would be a negligence of duty also. No general duty exists to aid a person in danger. In other words, while it is morally the thing to do to help somebody who is in danger, there is no duty that we have to do that. Okay, we do have a duty to take an affirmative action to protect students. An omission of not doing something when it should have been done will cause negligence of duty, and that can be a tort claim against a teacher. And again, that's a necessary step that we know should be done, and we choose not to do it, like repairing the football helmets or teaching the students about safety. And the obvious commission of a negligence would be doing something that shouldn't have been done. Standard of care. A negligence here, standard of care, it is the duty of teachers to keep students secure from injury. The amount of duty is fluid. It depends on the age, intelligence, maturity, and experience of the child. So those of you who are going to be or who are elementary teachers or were former elementary teachers have a higher standard of care upon you than a secondary teacher does, simply because of the age, intelligence, and maturity of the child. Let me give you an example of this and I think this example would fall under several of these categories, but I knew a couple of teachers once who they were teaching, and the student came in out of the hallway and said that there was a snake in the hall. And one of the teachers said he went out there, and sure enough, there's about a 12, 15-inch garter snake or something in the hall, a non-poisonous, non-harmful snake. And but they were trying to decide how they were going to get it out of the hallway. And so one of the teachers told the student, said, well, you just pick it up and take it out there. And so sure enough, a student picked it up and was taken outside, and guess what happened to it? Well, lo and behold, the snake got upset and turned around and bit the student on the hand. The student threw the snake down. They kicked it out the door. The teachers went back in the room and went back to work. That is an example here of standard of care. Those teachers could have been sued for negligence of duty. Now, nothing came of the student. Nothing happened to the student. He didn't get sick or anything. But still, that possible potential there, I think, could have really put them in harm. So, I say that because these are well-educated teachers. One of them had his master's degree, and yet they still got caught up in the moment, knowing the snake was harmless, and had to pick up the snake. So just be aware that even teachers, educated people, make bad decisions sometimes, and that could turn into a negligence of a number of things. But here I think it easily fits into a standard of care negligence. Proximate or legal cause. Here the Negligent Act has to have some form of harm associated with it. And again, with the snake, because it was a non-venomous snake, the kid didn't have anything happen to him. I'm not sure how far the negligence claim would have gone, but still, that would certainly be a black mark on anybody's record. Substantial enough, the proximate or legal cause, the legal cause has to be substantial enough to lead a reasonable person to conclude the act is indeed the cause of the injury. Well, obviously, if that snake had been poisonous, then the teachers would have been held negligent. Continuous and active force up to the actual harm. Injury or actual loss, nominal damages cannot be obtained where no actual loss can be shown or has occurred. And here's the interesting thing. Just because those teachers did something stupid, there has to be a loss or harm done. And in this particular case, there was no physical harm done to the student other than the student got bit on the hand. But again, that would have to have made it through the courts. I'm assuming those teachers knew the parents, and that's how they got away with that. Contributory negligence. So, contributory negligence, here is where basically what this is talking about is it's not completely. Let's go back to the example of the snake. The teachers didn't force the kid to pick up the snake. The kid obviously participated here. And the idea of contributory negligence says that if the student contributes to the negligent act, then they fail to exercise the required standard of care for his or her own safety, and therefore this would void the whole idea of negligence on part of the teachers. Now, that would be a good thing, but that's kind of going away. It's difficult to demonstrate or prove with children, but did they know, perceive, or understand the dangers and do the act anyway? All that's going to be relative. What we have more now is comparative negligence. And so let's say the student went to the hospital to get the snake bite looked at, and the hospital charged the parents $500. And they sued the school for the $500. What comparative negligence would say would be, well, the students and the teachers were both at fault here, and the student was at least half at fault and the teachers were half at fault. And so therefore the student would have to pay half the percentage and the teachers would have to pay half. So the student would pay $250 and each teacher would have to pay $125. That's what comparative negligence means. Okay, in a simple nutshell, it's taking a percentage of harm done and awarding rewards based on percentages. Assumption of risk. The plaintiff consents to relieve defendant of his duty or obligation of conduct. Assumption of risk requires voluntary consent, has to be aware of the dangers involved. Somebody going out for football, going out to a field trip, they're aware of the fact that there are dangers involved beyond just the ordinary day of going to school. Okay, and we'll talk about permission slips or exculpatory notes, as they call them in the law, in just a moment. But the assumption of risk here: duty of proper instruction and assignments not beyond the student's level of experience. All this is saying that a teacher cannot be held negligent if the assumption of risk is basically in the purview of what can be expected. Okay, so now we get into the idea of exculpatory notes or permission slips. And The jury is out here on this. This is interesting as to whether or not permission slips for field trips are valid assumption of risk. Some states say they are, some states say they are not, and schools are still liable. And to be honest with you, I don't know where Oklahoma is on this, but I can tell you, I put a teacher on a plan of improvement once for not getting permission slips for taking students. If anything, what the permission slip does is it notifies the parent that the student is leaving the school grounds and will not be at school that day. We made this teacher call the parents and let them know that she had their children off school grounds, and it was an ugly mess. But that all worked out for the better of everybody. But the exculpatory notes or permission slips, while they are always required, it is not carte blanche that the school is not liable anymore just because the parents sign those. An act of God, if an act of God occurs, then there is no liability. Natural calamities are foreseen, precautions required, or there is liability. In other words, if we know that there is a tornado coming and we refuse to take students to the storm shelter, then the school can be liable for that. But if we know a tornado is coming and we take them to the storm shelter and student trips or a student is hit by something flying, then the school is not liable for that. A prime example, just about 3 or 4 years ago, we let out school to send students home early because of ice coming, and we did it as fast as we could. The ice came up on us very quickly that year and this particular day, and it took a long, long time for the buses to make it home, because by the time we contacted all the elementary parents and got the kids on the road, the ice was falling. And so that would have been an act of God, though. We took all the precautions and did all that we promised that we would do. And luckily that day everybody got home safe, though. Immunity. Now, here's an interesting thing, and this is starting to change just a little bit. Initially, and this comes from the idea that the king can do no wrong. And in the Middle Ages, some kings were immune from the law. Governments cannot be sued unless the government allows the suit. And this goes back to the 11th Amendment. And parents have tried to sue school districts over the 11th Amendment, saying that as an entity of the government they could be sued. And initially the courts came up and said no, that they have immunity. It takes legislative acts required to abolish this immunity, and this has happened. But quite often what you'll see is a school district listed, but you'll also see individuals listed because it's the individuals who are actually being sued. Safe, harmless schools as an arm of the government have immunity from suit. This is slowly changing around the country. As we said, Oklahoma allows tort claims in certain areas with caps. So in other words, now parents can sue schools in Oklahoma, but there are caps on monetary rewards as a result of that. Okay, but for a while though, they couldn't sue any schools. They had to sue individuals because the school itself was an arm of the government. A couple of more things here dealing with torts. Educational malpractice. To sue a school for educational malpractice, you basically have to prove that the school did not educate the student. And this goes back to some issues involving students graduating and not being able to read. And the courts have basically really relied on schools or granted favor to schools in a lot of this and said that while the students are there and the teachers can do all they can, the teachers can't make the students learn that it's a home environment. Um, and therefore, we don't see a lot of the malpractice cases because of that mentality in the court right now. But that's basically what educational malpractice is. The burden of proof, it has to be the plaintiff, and in this case it would be a parent, has to show the school maliciously tried to prevent the child from learning. And I think that that's where a lot of these arguments fall apart, because unfortunately we can all probably think of incompetent teachers, but incompetence doesn't necessarily signify maliciousness, and I think that that's the key word here. Finally, constitutional torts. All those torts that we were just talking about really rely upon a state level. And when we're talking about constitutional torts, we're talking about national level. And a lot of this goes back to the Civil Rights Act of 1871. And this was right after the Civil War, and it was established by Congress to help protect slaves after the Civil War, or former slaves. And it talked about protection against race and so forth. But that's the basis for a constitutional tort. And the courts have interpreted, starting with that 1871 civil rights case, as you can see here, what a person is. A person includes individual people and local government or institutions. As I said, that law of immunity is changing. The only people who are completely free from these constitutional torts are prosecutors and legislators. And I find that interesting. The book really doesn't go into a lot of detail on that, but prosecutors and legislators are free from constitutional torts. Sometimes there are other state officials, and in here we're talking about I'm trying to remember what it said in the book. The main thing with the Schuer versus Rhodes case is the second bullet, that basically, as long as government officials, and here we're talking about school leaders, are working within the scope of their authority, they're probably going to gain immunity. When it comes to damages, so what kind of damages can you get from tort cases, whether it's assault and battery, whether it's negligence and a child is harmed at school for one reason or another? What kind of damages can you get? Actual damages are allowed. So in other words, if you go to the doctor because of extreme negligence on the part of the school and you're out $500, you can get $500. Punitive damages would be those for pain and suffering. And punitive damages are not allowed in tort cases, so you cannot sue for $500 for your hospital bill and $5,000 on top of that for pain and suffering. The only time that punitive damages are awarded is when it comes to civil rights cases. And this goes back to that 1871 Civil Rights Act dealing with torts. So that's just a quick overview of what a tort is. So basically it's the wrongdoing of a teacher or a school personnel on a student that does not constitute a crime. And most of this, as we saw, deals with negligence. And negligence comes in a number of areas: negligence of duty, negligence of care, and basically it's a teacher not taking the necessary precautions, and for that reason teachers can be sued for tort crime. So I hope that gives you a little bit of light on what a tort is for you.